going to be discussing an overview of the homestead exemption, the federal versus the state homestead exemption laws, claiming your primary home as your homestead, why Florida is the best state for homestead protection, what Florida homestead and creditor protection are, the homestead and property tax benefits in Florida, restrictions on alienation and devise, and how you transfer your homestead. Before we get into that, I just want to tell you a little bit about estate planning, because homestead is really a part of both estate planning and asset protection. What estate planning is, it's basically the managing and passing of your assets through the preparation of documents and retitling of your assets. We like to call this integrated estate planning because the asset protection and the estate planning work together and form a very, so you can't have one without the other, otherwise you have an incomplete plan. Everyone should have an estate plan because they all want to decide how they should dispose their assets at death. And you want to make sure who controls and who manages those assets. You also want to make sure that if you become incapacitated, that you're covered and somebody can be handling things for you for your best benefit. There are three types of homestead exemptions. First one is your homestead creditor exemption. And not every state has all three, but we're going to focus a lot on Florida today, which does have all three of these categories. So the first one, homestead creditor exemption, basically exempts a person's homestead from the claims of creditors. Very simple. The second one relates to discount on the property taxes for homestead property. And the third category is how do you pass your homestead property at your death? And we're going to cover all three of these. The first one is the homestead creditor exemption. That's the exemption of the equity in your home in the event of a creditor or bankruptcy. So just as an example, let's say your home's worth $500,000. That's your fair market value, and you owe a $100,000 mortgage. That makes your equity $400,000, the difference between the $500 and the $100. If your property weren't homestead, a creditor who gets a judgment against you force you to sell your property and take your equity. But if it's homestead, the equity is going to be protected. So that would mean you, if you're a debtor in bankruptcy, could actually keep your house as long as you agree to reaffirm your mortgage debt, which means you'd have to continue to pay that. But you'd be able to keep your house and you'd be able to keep all the equity in it. A homestead could either be a single-family house, a condo, mobile home. Some states like Pennsylvania allow it to be co-op. In Florida, you're protected up to 1/2 acre limits and 100 contiguous, which means attached and adjacent acres outside city limits. So if you live within a city, then you can only have a homestead property that's up to 1/2 acre protected. But if you're outside those city limits, if you live on a large piece of property, you can have up to 160 acres that's protected and the value protected from creditors. If your property is not in the city limits and it is more than the 1/2 acre, then you can consider transferring that property and having it own a limited liability company, or what your options are going to be in the event that your homestead is too big, meaning the property is too large. So there are factors that have to be considered when you make that decision, since mortgage deductions and capital gains exemption from the sale of property. And we're going to talk a little bit more about that when we talk about the different states that have much smaller homestead exemptions, where you might consider having a different type of ownership. Homestead exemptions are covered under state and federal law. The basic concept is that your state governs whether you follow federal or you follow state. So, like in Florida, state law governs, but Florida is actually better than the federal law, so you're in a good position. Some states have you have an option, so you can either follow federal or you can follow state, and some states say you have to follow federal. In Florida, you've got 100% protection from creditors if they have a judgment against you. On a piece of property, no creditor can get it unless you're in bankruptcy. And if you're in bankruptcy, they still can't get it unless you haven't lived in that property for 40 months, which means if you bought that property in 2012 and it's now the end of 2013, and somehow you end up in bankruptcy, then you only have a certain amount of equity protection. And what that means in Florida is each individual has $137,000 of equity protection until they've lived in the property for 40 months. You live in the property for 40 months, you have a complete protection. But before that, $137,000. Now, if you're married or you have a co-homestead owner, it's double. So you can double that protection to $274,000 of homestead protection for equity. There's also a time limit. You have to occupy the residence and for it to be your permanent residence and your intention to remain there. That's how you qualify for homestead. So just because you buy a piece of property doesn't mean it's your homestead. You actually have to live there, and you actually have to expect it to be your continued residence. Now, the one thing I want to point out is, yes, your homestead is protected from creditors. However, it's not protected against your mortgage company because they have a lien in the property, or the county property tax collector, other governmental taxes, if you have a homeowners association or condo association, or if you've done any work in the property that you haven't paid for, like haven't paid the electrician or the roofer. Those are called mechanics liens, and those can attach to the property even if it's your homestead because it's considered an actual interest in the property itself. If you want to get an idea of what the different state exemptions are, then please go look at our website, www.assetprotectionattorneys.com. How do you claim your homestead? Well, as I just said, you claim your homestead on the property that you reside in, and you have an intention of keeping that as your permanent residence. There's no official filing that's necessary for creditor protection purposes. What a court looks at is they look at the totality of the circumstances. Where do you put down your address for filing of your tax returns? Where's your driver's license address, your car registration, your voter's registration? Do you have a will in the state of Florida? They want to see all that in order to determine if you're actually a Florida resident and what your homestead is. If you want to further that position, you can always file what's called a declaration of domicile, which is basically a notarized form that declares your domicile, and you record that in the county that you're residing in. So for instance, you can have the homestead creditor protection and other federal protections for bankruptcy if you declare Florida your homestead. Even if you don't own property in Florida, you can still benefit from the other exemptions, the other financial exemptions, if you've got that declaration of domicile recorded. Now, one more thing. If you make a trust, like a lot of people do that for estate planning purposes, and what they do is they transfer their personal residence into the trust. I happen not to be a huge fan of that, especially if it's a married couple, because in Florida, your homestead, it's a fairly easy proceeding once you die. So I feel that it's better to keep it as husband and wife, tenants by the entirety ownership. But some people like to put it in their trust, just so you know you don't lose the homestead on the property if it's in the trust. So why Florida? Well, Florida is the best state for homestead because we actually have all three of the categories I've mentioned. We've got the creditor protection, the property tax exemption, and we have actually strict laws about how you pass the homestead at death. Most states have a much smaller homestead exemption. For instance, California, you've only got a $75,000 exemption for your homestead of equity in your property. And California's property values are very high, so $75,000 really doesn't mean much. It does go up a bit if you're over 65 or mentally handicapped, but it still doesn't go up very high. Same thing with New York. It varies by county. The highest is 150,000. Excuse me. The lowest is 75,000. With property values being what they are there, that really doesn't protect you very much. And we're in Florida, we've actually got 100% protection, unless, of course, you have that bankruptcy situation that I mentioned earlier, where you do have to own the property for 40 months before it's 100% protected in bankruptcy. And I just wanted to mention, if you see this is an O.J. Simpson example. So everybody remembers the case of O.J. Simpson in the 90s, acquitted under the criminal case, but he was sued civilly by the families of Goldman and his ex-wife, and they got a judgment against him. Well, he went ahead, and in 2005, he moved down to Florida and bought a monstrous house, very expensive house, and he declared that as his homestead. And that property is considered exempt from the claims of any creditor, including the plaintiffs in that situation. And in fact, I was just reading the other day that there's been some issue where he's now in jail in Nevada, and for I don't know how long, and he still receives what's called the homestead property tax exemption on that. And many people have complained, but the ruling was that it's still his residence, even though he doesn't actually live here. It's his intent to return, and therefore he can get a property tax exemption for that, which I thought was very interesting. Now I wanted to talk about the homestead property tax benefits, which we just mentioned with O.J. Simpson. So how that works is if a property is your homestead, you can get up to $50,000 off the assessed value on the property, and you pay tax on the assessed value less that $50,000. Now you can only have one exemption at a time, and that's critical, because if you own multiple properties, you can get a homestead exemption, but it can only be on your primary residence. And that's where you live more than 180 days of the year, and that's where you intend to remain. That exemption is issued by the county that the property is located in. And what you need to also understand is that spouses, if they reside separately, can have a separate homestead, which means they too can get $50,000 off the assessed value, but they have to legitimately live in that residence, the same thing, over 180 days a year, with the intent for it to be their primary residence. Now, to get the homestead exemption, you have to apply by March 1st of the year following the purchase of your home. So as long as you owned your home by December 31st, you have till March 1st of the following year to apply for your homestead. You can do this online, but just as a caveat, if you're going to do it online, there's a lot of information they ask you, so you want to go through the application first in order to know what information you need to have handy, and don't wait for the last moment, because if you do it online, you know, your confirmation may not come through before the deadline, so you do have to be really careful about that. Otherwise, you can go to your local tax collector office and wait there. If you wait if you wait until the end of February, I can tell you from personal experience, you'll be standing outside for a very long time. You're better off doing it sooner rather than later, because it'll take you just a very short time if you do it with some time to spare. Now, if you move from one county to another county, you have to make sure to cancel your homestead in the old county. I had a client a few years back who had lived in Tampa, and then she moved to South Florida to Palm Beach County. She kept the house in Tampa as a rental, and it was a very expensive house, and applied for homestead in Palm Beach County, and didn't realize that she had to cancel the first homestead. So for years, she was just paying whatever the tax bill was that they sent her. And then all of a sudden, they sent her a bill for $1,000 in back taxes. It was actually more than $30. In back taxes, interest and penalties, and said you need to pay, I forgot how many days it was, or they were lien property and continuing to charge interest and penalties, because she hadn't canceled her home and hadn't really thought about it, because she assumed one Once you applied in Palm Beach County, it would cancel out any other homestead. So please make sure if you ever do move, and you move counties at least, you need to make sure that that's changed. One other thing you want to keep in mind is, what happens if you put somebody else on? Does that affect your homestead for property tax exemption? If the person you put on is your spouse, it's not a problem and they're living with you. If you, let's say, put on an adult child, which is not unusual for people, especially in Florida, then if you don't do the deed properly, then the parent could lose up to half, potentially more of their homestead exemption. So if that's something you want to do, then you need to make sure you see a real estate attorney or an estate planning attorney who does real estate to make sure that they have properly constructed the deed so that you can still retain your homestead exemption and the property will pass without probate at your death. The last part of homestead exemption that we have in Florida, it's available in some other states, but again, we'll focus on Florida today, is a restriction on the disposition of the homestead at your death. For example, if you're married and you own the house but your spouse is not on title, you can't actually mortgage or sell the property without your spouse's consent. And you can't even give it away by will to anyone else. So if you want to get a mortgage, your spouse has to sign the mortgage. They don't have to obligate themselves on the note, but they do have to sign the mortgage. If you want to sell the property, they have to sign on the deed. Basically, they are consenting to the fact that you are doing something with your homestead. Now, when you die, there's some options. But first we have to look at who's around after you're dead. First thing is, did you have a spouse? Do you have minor children? If you had a spouse and minor children when you died, and the property was just in your name, then your spouse actually gets the choice. He or she can take 50% of the property, and the other 50% goes to all your children, or the spouse can take what's called a life estate in the property, which is the right to live there for the rest of his or her life. They'll be responsible for the expenses and things of that nature. And then your children own the remainder interest, which will pass to them at your spouse's death. If you have no minor children, and you have no children or just adult children, then you can actually leave it to your spouse directly in your will. If you don't leave it to your spouse directly in your will, then the same thing happens. The spouse can take 50%, the children get the other half, or the spouse can get the life estate and the children can get the remainder in the property. Now, if you have no spouse or minor children, then you can leave that property any way you want in your will. And there's a very short proceeding that goes along with homestead. It does go through the probate court, but it's a very simple proceeding, and because it's exempt from the claims of creditors, it doesn't take very long. But you do have to consider that you are really not free to give your homestead away if you've got a spouse or minor children. And I've actually got a client who's been working on her estate plan for 2 years because she's involved in a second marriage. Her house is very expensive, and she doesn't want the property to pass the way the state law is going to require. Now, I suggested she get a post-nuptial agreement to solve the problem, but her husband won't sign. So we've really been working on this. It might even be more than 2 years now. So these are considerations that people don't realize, and that's why it's important to make sure you see an estate planning attorney and let them explain everything to you. Now, how do you transfer your homestead? Well, it's very simple. You can transfer your homestead while you're alive by a deed, just as if you would transfer any other real estate. But keep in mind what I said earlier, if you're married and your spouse is not on title, then your spouse has to sign the deed because they have to consent to the fact that you're selling your homestead. Now, what you have to look at is, are you going to buy a new homestead? Because if you're going to buy a new homestead, then ideally what you want to do is close on the first property and take the proceeds from that sale and invest it immediately in your new property. That way, there's no question you have not really lost any homestead for creditor protection, and you have haven't lost for property tax purposes, because you can just, it's called portability, you can transfer that exemption. Now, there are situations, especially now with the market being what it is, where there are actually properties selling so quickly people haven't had a chance to buy another house, or there's no inventory. So what do you do, and how do you protect those proceeds? Well, what you do is, if you sell your house and you don't have another one to invest in immediately, open a bank account. You're going to call it, whatever your name is, Homestead Proceeds. It's not a special account. It's savings, checking, whatever you want to do. And you're going to take the amount of money that you received from the closing, so the check that you got, and you're going to deposit that full amount in this new account. You're going to put nothing else, segregated account. That money is going to be safe for a reasonable period of time. What courts have interpreted as reasonable is about 6 months. So you've got about 6 months to play with to go and reinvest that money in a new homestead so that it's protected. If you go beyond the 6 months, it's going to be a case-by-case basis, but you really want to try to get it within this month so that you don't have any sort of issue that you have to fight with. It's important you don't use that money for anything else, and you don't any other money in it. It has to be a segregated account. That's all we have on home. I just want to go a little bit into the overall estate plan. I said earlier, everyone should have an estate plan. You should have it reviewed periodically. What that means is, did you get married? Did you get divorced? Did you have a new child? Do you have a child or another beneficiary who might have special needs? Did you move to a new state? These are all reasons to have your estate plan looked at. I always suggest, if you want to look at it even randomly every 3 years, it's important just to make sure you're in compliance with any new laws. Your attorney is not necessarily going to have the facility to send out a memo every time a new law changes that might affect you. So it's important to check in.